Recognised podcast published by the Meritas EMEA Employment Group. Periodically, members of our practice group get together to discuss interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray-Hinde and I'm a lawyer at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Emma Richmond from Whitney Moore in Ireland, and two voices you'll recognise from other episodes, Kato Aerts from Lydian in Belgium, and Hans Helwig from Graf von Westphalen in Germany. All are employment lawyers and specialists. And our discussion today is on whistleblowing. Now, I would describe whistleblowing as a kind of early warning system. So it's designed to encourage employees to speak up without fear of retaliation and to have recourse should they suffer a detriment or be dismissed for making a disclosure to either their employer or, in certain circumstances, a third party such as a regulator or even the press. Here in the UK, the whistleblowing charity Protect is calling for reforms. And sadly, while we were a trailblazer with whistleblowing protection coming into effect back in 1998, we are now lagging behind. And the government reviewed these laws in 2023, and Labour's Employment Rights Bill sets out its intention to strengthen protections, but it's not a centrepiece of their plans. What Protect is seeking in the UK is for there to be a duty on employers to investigate whistleblowing concerns. At the moment, there isn't an obligation to actually investigate or take action, so our provisions lack teeth. For the range of people who qualify for whistleblowing protection to be expanded, and to reframe whistleblowing as a vital tool for upholding standards in public life. And now I want to turn to my guests today, as all of them being from countries within Europe, I think we'll be keen to discuss what the EU Whistleblowing Directive already addresses in terms of what Protect is seeking within our UK legislation. So, Kato, I'm going to ask you first to tell us what whistleblowing looks like in Belgium. So, what options are available to someone who's brave enough to speak up and report misconduct, and kind of walk us through that process?
Sure, thanks, Sam. So in Belgium, there are actually several pieces of legislation covering whistleblowing, both for the public and the private sectors. But for today's episode, let's maybe focus on the Whistleblowing Act of November 28, 2022, which applies to the private sector, since that's the most widely relevant law in Belgium. When it comes to blowing the whistle, there are three main ways to do it. Internally within the company, externally through official channels and authorities, or through public disclosure. And I think most of our listeners will probably be interested in how internal whistleblowing works within a company in Belgium. Not every company is required to have an internal whistleblowing channel. It all depends on the number of employees they have. Private companies with at least 50 employees must set up a whistleblowing channel, and to determine if they hit that threshold, companies need to check their headcount every January 1st, looking at the average number of employees over the past 4 quarters. If that number exceeds 50, then an internal whistleblowing system is mandatory. Having said that, there is an exception for financial sector companies because they do need to have a whistleblowing channel, no matter how many employees they have. And then if a company does have an internal whistleblowing system, at a minimum, employees must have access to it. However, businesses can choose to extend access to other groups of people like consultants, shareholders, trainees, and certain others who might come across reportable information in a work-related context. This extension is not mandatory, except for companies in the financial sector, again, where broader access is required. As to what kind of breaches should be reported through these channels, the law lays out a specific list, mostly taken from the EU directive you mentioned already. This includes areas like public procurement, food safety, consumer protection, and the list goes on. But Belgium has also added social and tax fraud to this list, which is something that is fairly unique to our legislation. And then in practice, though, we are seeing that many companies are choosing to expand the scope of their whistleblowing channels beyond of what's required from a strictly legal perspective.
So with those whistleblowing channels, sometimes they might be set up by maybe the parent company. So is that going to be enough to cover a company's obligations? Do they need to have local policies in place, or can those employers just simply rely on the global procedures?
That's a very good question. There's no strict requirement to have a separate local procedure just for employees. Companies can absolutely use a global whistleblowing hotline to receive reports. However, it is important that the entire management of the internal whistleblowing system cannot be outsourced completely to a group level entity or an external provider. So that means that there still needs to be a dedicated person within the Belgian legal entity responsible for following up on reports and providing feedback to whistleblowers. So let me break that down a bit. Companies with fewer than 250 employees are allowed to share resources when it comes to receiving and investigating reports. And in fact, the European Commission acknowledges that medium-sized subsidiaries within a corporate group can make use of the parent company's investigative capacity. But there are several conditions, among which the fact that local reporting channels must still be available and feedback needs to be provided at the level of the local entity. So to sum it up, even if companies rely on a global system for receiving reports, they must still appoint a dedicated person at the local legal entity to handle follow-ups and ensure compliance.
Okay, and so Kato was mentioning there about the kind of people that have access to these channels. And Emma, just looking at Ireland's position now, I think it'd be helpful if you could tell us about who can make a protected disclosure under the Irish legislation.
Yeah, and similar to Belgium, obviously the Irish legislation was reviewed and updated on the back of the EU directive. So our most recent legislation came in 2022. And they're also, that kind of broadened out those that can make a protected disclosure. And there's a misconception, I suppose, that it's limited to employees. But in fact, it's far wider than that. It includes contractors, it includes volunteers within organisations, which is particularly relevant in terms of charities. There's been a number of whistleblowing allegations in relation to charities. So given the number of people that will volunteer within charities, that's a particular group where a lot of whistleblowing allegations have arisen. It also includes people who are applying for jobs. So they may not even be an employee or engaged directly by a business at that stage. So it is particularly broad. And again, as you mentioned in your introduction, it really is trying to promote that culture, that speak up culture within organisations, and the EU directive, that is a lot of the aim of that directive, is to create that culture within a business.
Yeah, I think it's a really interesting comparison to make with the UK, because our protection covers employees and workers, and then we've got some special provisions around job applicants in the NHS, those employed by the government or Crown, and the kind of armed forces provisions. And a worker is more broadly defined under this whistleblowing legislation because it can include office holders as well, but it's still very narrow compared to the position in some European jurisdictions. Hans, so turning to Germany now, what's the position there around procedures and processes?
Well, actually, I can, well, thank you very much. Actually, I can copy everything Kato said, because it really sounds like it's more or less identical to how the procedures work in Germany, and the thresholds regarding the number of employees and making use of corporate or existing corporate systems. One particularity maybe we have in Germany specifically is the involvement of the Works Council. Mm-hmm. This I don't know how far that is similar to other jurisdictions in Europe, because as an employer, you usually don't simply apply the law, but you want to have some policy, like how actually employees make use of the system. How can they use the reporting channel? How can they report a breach of duty or misconduct or what they are suspecting? And as soon as you do this, like you go beyond what is prescribed by law, you have to involve the Works Council for such policies. And the same applies if you want to make use of a tech tool. Like many reportings in Germany, or for many reportings, companies use like an IT tool where you can just visit a website and there's a link on like most companies' websites where it says whistleblowing, and then you can make use of that, which is, I think, particularly good, because that's how you can secure anonymity at the easiest, so people do not have to disclose their names if they just go through this IT tool. But then also you have to involve the Works Council because that's prescribed by the Works Constitution Act that whenever tech is used in the context of employment, they want to make sure that you don't abuse the tech tool to the detriment of the employees. So this could lead to make it a little more complicated to have discussions with the Works Council on how actually implement policies and what is the legal framework of reporting within the whistleblowing direct policies.
And in terms of that reporting, is there an actual obligation on employees to whistleblow about misconduct by colleagues? I mean, I know in the UK there isn't a particular duty unless it's in a contract or if someone's in a kind of fiduciary position, but I don't know what it's like in Germany.
It's a very interesting question because there is no, I mean, that's been a big discussion within the procedure, the legislative procedure, like implementing the EU directive into German law. And I think that's one of the points where they discussed on the most, because you can ask the question if there's not an obligation to report, what is the sense of the system, because nobody can be held liable if they actually are aware of a misconduct or breach of duty and then they don't report it. But that's how so it's similar to the UK. There's no obligation for any employee to report, whereas I mean there's the duty of loyalty to your employer. So but what does that mean? So it's a really difficult situation right now legally, I think.
Yeah, I think it's also the interesting point you made around the kind of reporting channels and having that process in place, and a lot more employers using those companies where you can click on a link and make your whistleblowing allegations. And we talk to clients about having those reporting channels, but obviously they're not prescribed under the UK legislation. And when we were helping Lord Patel with the Yorkshire County Cricket Club work, we set up a whistleblowing hotline overnight to try and bring out the complaints and get them dealt with and try and deal with that crisis. And that was actually just an email account that people could send their complaints to. Some of them actually set up their own email address to do it. So it was kind of more anonymous. It wasn't a kind of email address which had their name in, which I think made them feel more comfortable. And I just wanted to ask Emma about the position in Ireland and what businesses need to do there to deal with these protected disclosures. Is it similar to what Hans was saying about Germany?
Yeah, we don't have works councils, so we don't have that added challenge, but it is those internal reporting channels that need to be available to make a protected disclosure. And again, similar to Kato in terms of Belgium, there can be a group level reporting channel, but they need to have a dedicated person within the local country. And again, one of the key elements to making a protected disclosure is that confidentiality piece and the anonymity if the party wishes to keep themselves anonymous. And certainly in terms of Ireland, there has been a huge increase in whistleblowing since the new legislation came in on the back of the EU directive. The legislation came in the beginning of 2023 for, again, organisations with over 50 employees in the private sector. And to the point that we've now seen a 200% increase in protected disclosures / whistleblowing in Ireland since that new legislation. So those reporting channels do appear to be working. But one of the concerns that has been raised is that where often a protected disclosure may be raised in the context of a grievance to a manager. And it's really critical that whilst you might have those procedures and internal reporting channels, that a business is also training their managers so that they can identify when something is actually a protected disclosure if it's raised in the context of a complaint or a grievance.
And I think all of us have talked about these kind of written policies that employers have in place. We have them in the UK as well. It shows that an employer is encouraging people to speak up and trying to work on that culture. And I wanted to ask Kato what the risks of not having that written policy in place.
Well, technically, a specific policy is not mandatory, but employees do need to receive clear and accessible information about how they can file an internal report and what the procedure looks like. So the easiest way to do that is with a dedicated policy. We usually wouldn't recommend including this information in work rules. That's a mandatory document under Belgian law, more or less a employee handbook, if you will, or a collective bargaining agreement, because having that in a separate policy gives companies the flexibility to update the procedure when needed without having to go through a formal process. But when you set up a channel, just like Hans already said, you have to have prior information and consultation with the Works Council and other social partners at company level. So that is indeed correct. One thing to keep in mind is that this policy must comply with Belgium's language requirements, which I'm sure is something unique to my country. So that means that the policy has to be written in Dutch, French, or German, depending on where the company's exploitation seat is located. And that is something that often gets overlooked in practice. Now, what happens if a company fails to provide clear information on its internal reporting channel? Well, in theory, there are serious consequences. Employers could face imprisonment even for 6 months up to 3 years, or a criminal fine ranging from 4,800 to 56,000 euros, or alternatively, they could be hit with an administrative fine between 2,400 and 28,000 euros. That said, it is all relatively new legislation, so it's still unclear whether Belgian inspection services will actively enforce these penalties right away, or seek to enforce these penalties right away, or if they'll take a more lenient approach in the beginning by giving warnings, for instance.
I think that criminal element and the fines there, that's quite interesting, whether that's kind of, making employers actually step up and take these obligations seriously. So I'd be really interested to see how that plays out when you start getting cases coming through. And just looking at the kind of dispute point, one of the main goals, as I understand it, is that the EU directive is, protecting the whistleblowers. And there's that kind of interplay between their rights and kind of data protection rights as well. And I wondered, Hans, if you could talk to us about what happens if someone whistleblows and they investigate, they talk to the alleged perpetrator, and that perpetrator wants to know who the whistleblower is.
Yeah, I think it's super interesting topic, really, because there's no yes or no. I mean, typical lawyer's answer, I guess. Because I mean, from like within like legal literature, everybody is of the opinion that like somebody the employee reporting is, and who's like honestly reporting and not like submitting some like fake allegations to hurt like a coworker, that they are protected and they should not. So everything they report to the channel should be protected, and the perpetrator does not have the right of information according to Article 15, which usually GDPR, which is usually the tool of choice to find out who's behind that reporting, and they don't have the right to, or the employer does not have to disclose the name and also the content of the reporting. However, there are recent judgments by inferior labor courts who say that data protection is the higher good compared to the Whistleblowing Act, which I personally don't share. But certainly the biggest problem will probably always be that the alleged perpetrator, they will say, well, the reporting is wrong, so that according to the Whistleblowing Act or Whistleblowing Directive, there's no protection to the whistleblower, because if somebody files a wrongful accusation or wrong accusation, then they are not protected under the Whistleblowing Act. I assume that is the same in every country. And then you have, of course, the right, the data protection right of information by the alleged perpetrator. So that's a big discussion in German law right now, and every employee is advised to, or the good advice to every employer is to do thorough documentation of why they refuse to answer to that right of information request by the alleged perpetrator, so they can, if there would ever be an investigation by the data protection authorities, they could document why they think it's the higher good to protect the person reporting.
Yeah, I think these tensions are really interesting and quite difficult to manage in practice. because you have all these different competing rights and balancing the rights between the whistleblower and the perpetrator, and that perpetrator needing to know enough about the allegation against them to be able to defend themselves in a kind of internal process. And I think it's difficult with employers when they're putting in place procedures to kind of be able to promise, confidentiality and anonymity because of the way things could play out. So it's really difficult, and just having to sort of, I guess, keep things under review as the processes go forward. I wanted to pick up on something that Emma said about the uptick in whistleblowing in Ireland. Did you say it was 200% higher because of the directive and the obligations now? And I thought it'd be interesting to ask each of you whether you think the legislation is kind of working as it's intended. Is it beneficial? Is it kind of helping employers to deal with these issues, bringing them to the fore? Or do you think there's still areas of reform needed? I don't know who wants to go first.
Well, I'm happy to pick up on it just in terms of those increasing claims and what we're seeing in terms of the nature of claims that are being brought. And one of the challenges is there, to some extent, that the legislation's being somewhat exploited. Whilst obviously there's that purpose of that speak up culture to try to highlight any wrongdoings within a business, there is also an element that because of the awards that can be made under this legislation, and in Ireland, if an employee is dismissed as a result of making a protected disclosure or whistleblowing, they can be awarded up to 5 years' salary. So, where you have an employee perhaps undergoing a performance management plan and they're looking for a tool to arm themselves with, well, the easiest way is to make a protected disclosure. And then subsequently, if they're dismissed on the grounds of performance, they're then saying, well, actually, I've just been penalised because of my protected disclosure. So the legislation, I think, is being twisted slightly. So it's not necessarily just purely driven in that speak up culture. So I'm not quite sure how you fix that when there is such a high level of award there. There's an attraction to claiming under that piece of legislation. But I do think that's a gap in the current system at the moment in Ireland anyway.
Yeah, it gets used in the UK a lot because of it being a day one right. So you don't have to have 2 years service like you do with unfair dismissal, because it's a kind of automatic unfair dismissal type claim. Kato, did you have any perspectives on Belgium?
I agree with what Emma said, that abuse is, of course, wherever there is a protection, that abuse is hard to exclude, and that happens in practice. Overall, of course, I think we can agree that whistleblowing as such is a positive step, and companies should foster a strong speak up culture. When employees feel safe raising concerns and trust that their reports will be handled properly, I guess that's a big step towards building a strong ethical foundation within an organization, which is, of course, very positive. I think a major improvement is at the same time the protection that we mentioned against retaliation, which is crucial to provide that safe speak up culture. And on that note, I found it really interesting that the European Commission has funded the Bright project, which created a temporary tool called SUSA. And this tool allows companies to assess their own whistleblowing channels anonymously, giving them insights into how well their internal system is working and whether it is aligned with the international standards and the EU regulations. So it's a great way for organizations to self-check and test their compliance without exposing their identity. And then one particular point to mention for Belgium is that having a well-drafted whistleblowing policy is essential to avoid confusion, because there are already existing reporting lines that remain in place for instance, workplace harassment, which is a very specific process under Belgian law, and which typically involves the health and safety advisor or a designated person of trust within the company. And that's totally separate from the new whistleblowing legislation. So this can sometimes create confusion, especially for employees who do want to report issues like sexual misconduct, but aren't sure whether they should go through the whistleblowing system or the existing workplace harassment channels. And that's why I think, especially in Belgium, companies should include clear guidance in their whistleblowing policy to help employees navigate these different reporting options.
Okay, and turning to Hans.
Thank you. I think I totally agree to Kato that certainly guidance and policies and also training is crucial to make this a success. My personal perception is, and we also act as an internal reporting channel for quite a number of companies, is that German employees are still kind of like reluctant to use these channels. I think it's my personal perception also from discussions and cases we have, that they're only very slowly trying to use these reporting channels, whistleblowing channels, because they still are in fear of detriment, although if they do it anonymous, they wouldn't have to fear it. But I think there's the trust base is not yet there. This is my perception. So we don't have that many cases really coming up through the channels.
Yeah, I think I can probably easily summarize our chat today by just saying that whistleblowing seems to go hand in hand with culture within organizations. And having that kind of speak up culture backed up by these whistleblowing protections can only be a good thing, because it's giving the employer a chance to address the genuine issues and to stop them being perpetrated. And as Hans has said, that all of that is kind of built on trust. It takes time to build up. And regardless of what any legislation says, I think employers should be having, whistleblowing policies drafted and put in place to give them a framework for dealing with these issues. And it's really important that they then do take action when things are reported. I think I'll leave it there for this session. It's been a really great discussion. If any of our listeners have any comments or questions on the subject, then please do get in touch with your Meritas contact firm. We'd be happy to continue the conversations with you. Or if you'd like to find out more about Meritas, you can do so via the website meritas.org. And that just leaves me to thank Emma, Kato and Hans for joining me today, and we hope you'll tune in next time.